Hello and welcome to Part 2 of the NC State and FTCOE's virtual workshop series on qualifications of an expert witness for legal professionals. First, we will hear from Chris Fabricant with the Innocence Project on establishing the Frye Standard, a brief history of scientific expert admissibility. Without further delay, here is Chris.
Hi, my name is Chris Fabricant. I'm the Director of Strategic Litigation at the Innocence Project in New York and author of the book Junk Science and the American Criminal Justice System. I'm here today to give you a brief history of scientific expert admissibility told through the lens of the Frye Doctrine. So Frye goes all the way back to 1923, a case arising out of the District of Columbia, which involved an early challenge to early use of a lie detector test. And up until that point, there hadn't been a need really for a standard for courts to consider as to whether or not they're going to admit purportedly scientific evidence. And faced with this novel issue, the DC Court of Appeals decided, in some of the language that I have quoted here on the slide, not to admit the proffer of expert witness testimony because it had not gained such standing in scientific recognition amongst physiological and psychological authorities that would have had some say as to whether or not it actually worked. In other words, it wasn't going to be accepted by these fields of science, and it hasn't been at that point. And so they said that while we'll go a long way to admit such testimony, unless it's really accepted by scientific authorities, we, the courts, are not going to admit this test. And this is some of the language that was recorded and that's been widely admitted and used for many, many years. And they're saying that it's like, while the courts will always go a long way in admitting testimony deduced from well-recognized scientific principles or discovery, the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. So what seemed to be a very straightforward opinion ended up having widespread influence around the country and was adopted by overwhelmingly in states across the country. As a result, it really boiled down to its essence. The Frye test became kind of the shorthand for Frye would be whether the technique has been generally accepted in the relevant scientific community. And that is more to unpack than you might think. And this became the go-to test for around the country. And so from 1923 until 1993, it became the dominant standards. And really what this was courts had decided that they are going to defer to the scientific community. Scientific illiteracy is a widespread problem in American culture, and certainly the bench and the bar are no different in that many people go to law school because there's no math. And so the idea is that we, judges, lawyers, really ought to defer to those whose expertise in this field is much more persuasive than what a judge might decide about a particular validity or reliability of a particular technique. And so then, courts became adept at grappling with these issues and really, what does it mean to be general accepted? How is that defined? And so in many states, it was really simply a matter of counting noses. Do the majority of the scientists in this field accept this particular forensic technique or whatever scientific evidence was being proffered? So a simple majority would do. But the idea was that it had to have gained general acceptance before it would be admitted, right? So a new technique would be much less likely to be admitted than something that had been established and used for some time. And really, again, courts were deferential to the scientific community. And while the standard has been around for many, many years, it was really in the post-World War II era that scientific evidence became much more widely used, and we may be talking a lot about criminal cases here, but of course, scientific evidence is used in civil litigation as well. And in the post-World War II era, particularly in the 70s and 80s, we had this explosion of personal injury litigation, toxic tort liability, product liability, personal injury, medical malpractice, an entire cottage industry sprung up to support civil litigation and personal injury litigation. Expert witnesses proliferated. From 1978 until the early 90s in Chicago, for example, there was 1,500% increase in the use of regularly testifying expert witnesses. Experts became so common and so widely used that many people from the fields were no longer actually working in the fields, but were instead serving as professional expert witnesses. So what had once been a relatively modest area of the law had become increasingly important, and more big money was at stake with whether or not a particular scientific theory was going to be allowed into evidence at trial. And what was happening during this period is that many big businesses and big corporations were being sued by plaintiffs' attorneys, and they were using a lot of these professional expert witnesses. Some of that testimony that was given was valid and reliable and properly admitted, and some of it was junk. A lot of it was junk. And what was happening was that corporations like the Dalcon Shield litigation or some of the other kind of high profile litigation during that era is that corporations were unsuccessful in challenging expert witness testimony that they believed was not reliable. And how it was being defined, how Frye was being defined and interpreted was really important as to how you're going to define the relevant scientific community. And what the corporate bar was complaining about was that courts had been essentially gerrymandering and defining the relevant scientific community as those experts whose essentially their livelihoods depended on the continued acceptance of whatever field or technique or discipline that we were talking about. In other words, those who kind of own the science and were making a living in the science were telling the courts whether or not it was valid and reliable. So a very influential book was released in 1991 called Galileo's Revenge, Junk Science in the Courtroom. And what this was by Peter Huber, who is a fellow at the Manhattan Institute and a former law clerk of Sandra Day O'Connor's, had written this polemic on the junk science that was being used in civil litigation. And his book is actually credited with coining the term junk science. It wasn't something that was in our popular culture up until that time. And it was part of a large corporate effort for what they started calling tort reform, because they were getting windfall verdicts in personal injury and product liability litigation. And corporations are getting tired of it, right? And they wanted a new standard for judges to stop necessarily deferring to the, so-called relevant scientific community, but to make some independent judgments about the reliability and of a particular type of purportedly scientific evidence. So really the junk science debate and the tussling over interpretations of Frye hadn't really been engaged by the criminal law community as much as it had been the civil community, particularly in the 90s. And so what the corporate bar did was tee up a case called Daubert versus Merrill Dow Pharmaceutical. And this is the most important Supreme Court case on scientific evidence. And what the court in Daubert did, despite certainly Justice Rehnquist, amongst others, are very uncomfortable with judges making any independent judgments about science because it's outside of their field. Nonetheless, what the court decided was that federal judges anyway, were no longer going to defer to the scientific community. They're going to have to eat their broccoli, and they're going to have to make some independent judgments, roll up their sleeves, and do some homework. And the court laid out a 5-part, non-exclusive, but it really has become essentially a 5-part test, and asked judges to make judgments about answer these questions as they relate to purported scientific evidence. One, is it testable, right? In other words, could you prove or disprove whether or not this technique actually works, right? So if you think about something like bite mark matching, you wouldn't really be able to prove that that works because you can't test it on human beings and bite people and match them to the teeth, right? So it's not really a testable hypothesis. And it's not ipse dixit, which means it is so because I say so, right? If an opinion is just coming in talking and it's only relying on training and experience, that's not scientific evidence. That's just an opinion. That's just somebody saying it is so because I say so. So the court said, no more of that. And then they talk about science has to be peer reviewed and published, right? So what that means is that it's published in a refereed journal, and usually there are blind submissions, so they don't know who the authors are. And it's reviewed by disinterested scientists, then published, and then other scientists seek to replicate those tests through the peer review process. And what it isn't is when one expert comes to a conclusion, then gives it to his peer and has the peer review the work. Sometimes many courts were confusing that, many lawyers, that was what peer review meant. But of course, that's not. Also, what was important was the known or potential rate of error rates, right? So you couldn't come in and just say 0. And it also meant that it wasn't a proficiency test. It's not an error rate. It's an error rate for the field, and it's an error rate for an individual examiner. How often does the field get it right and wrong under the same circumstances? And how often does the individual examiner get it right and get it wrong? The persistence and maintenance of standards were also very important. So in other words, and maintenance is very important because science changes. It's a process, always moving forward. Law tends to be more static. And so what was important is that when science is moving forward, that in a field, the guidance, the standards that control the field, one, that they're standards and actually they're mandatory. In other words, they're not just guidelines. And two, that they're updated, right? So when we have new data, we update our standards. It doesn't mean that these are suggestions or you might do it this way or you might do it that way. Standards and maintenance of standards. And then the last was that they incorporated the Frye test into this larger test, and so what I'm going to talk about in a minute was many of the ways that these 5 tests, these 5 factors play in, is that when a court was deciding in a Frye jurisdiction whether something was generally accepted, if it didn't pass any of these, if it wasn't testable, if it had never been peer reviewed, if there were no standards, typically that discipline would not be generally accepted, right? So the test is different. You would still defer to the relevant scientific community. The relevant scientific community traditionally would not accept, or certainly not gain widespread acceptance, if a scientific discipline had not been peer reviewed, had not gone through, could not check these boxes. So what it also meant was that we were not going to allow a small group of experts to find the relevant scientific community for an entire legal field. So big business won. They had a new standard, and one study that 10 years after the Daubert decision came down showed a 40% increase in exclusion of plaintiffs' experts from testifying at trial. 40% is a big number. So it was a seismic change on the civil side of scientific litigation. Frye was becoming obsolete in many jurisdictions. All federal courts were required to follow Daubert, and states across the country began adopting this new standard more and more and more, and but many states still retain Frye. And what happened in that changed the conversation around the use of scientific evidence and the Frye Standard on the criminal side of things were a couple of things. I'll start with the bottom, is that with the advent of forensic DNA testing in the late 80s and early 90s, the development and the establishment of the Innocence Project and similar organizations after that, DNA was used as essentially a truth serum, or that we would have scientific certainty about certain questions that were important to deciding guilt or innocence that we had never had before. There were no other techniques that were capable of providing answers to unknowns in the way that DNA could. And as a result, what we've learned is that through DNA exonerations is that more than half of all known wrongful convictions involved the use or the misapplication of forensic sciences. And so these are the techniques that we're relying on to provide objective evidence to decide guilt or innocence. life and liberty questions. And so this was kind of a shock in the forensic community, although the early exonerations did not change much as it relates to interpretations of Frye or the use of scientific evidence. But fast forward until 2006, and that was when Congress had taken notice of all the wrongful convictions and some of the problems with some of the forensic techniques that were in widespread use, and asked the National Academy of Sciences, which is the most prestigious scientific organization in the country, if not the world, to examine the claims that had been accepted in courts around forensic sciences for a century, to put them to real scientific scrutiny. Independent, objective, disinterested scientists were going to look at the claims that had been accepted in criminal courts through the Frye test for 100 years. And it ended up with being a lengthy document, and it looked at 13 different forensic techniques. But one of the things that it noted was that this debate, and the National Academy of Sciences pointed to Peter Huber's book, Galileo's Revenge, and he said that that he had popularized the well-known phrase junk science to criticize the judiciary's acceptance of unreliable techniques. And what the highlighted language that I have here, though, is what the National Academy of Sciences pointed out and said, despite these highly visible efforts to reform governing experts in the civil arena, the junk science debate was all but ignored in criminal prosecutions. And the visible efforts were Daubert, right? This effort to make more scientific opinions from purported scientific testimony. And so the NAS, as it was reviewing this and was highly critical of many forensic techniques, had noted that this debate in law had been going on for a long time, and Daubert had changed those principles, but it was still happening, and that Frye was part of the problem, and that the junk science debate had not been moved into criminal court. One thing I will go back to, though, is the point that I was actually trying to make before. And what was, if you think about jurisprudence as it relates to forensic sciences and trace evidence in particular, and when I say that, I mean things like fingerprints and tire treads and shoe prints and bite marks and hair microscopy and all these techniques, and firearms and tool marks, or sometimes referred to as ballistics. What we have, and still sometimes today, is testimony that gun fired that bullet to the exclusion of every other gun manufactured in the history of time, or that screwdriver made that mark on that window sill to the exclusion of every other screwdriver ever manufactured. And we get that type of individualization type testimony in courts, and courts had accepted this through the Frye challenges, overruling Frye challenges to that type of testimony for a long, long time. And so when the National Academy of Sciences finally looked under the hood, beginning in 2006, and then did this 3-year investigation culminating in their report in 2009, while they critiqued 13 different disciplines and found them all lacking in various ways, one of the real takeaways from the entire report was this language that I have quoted here, them saying, with the exception of nuclear DNA analysis, in other words, not mixture interpretation, but nuclear DNA analysis, however, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. Now, we've been accepting that testimony for a very long time, and here was an earthquake in the forensic science community and in the law, because the law said that those types of opinions were valid and reliable, that they were widely accepted in the relevant scientific community according to the Frye test. So we had, for the first time, what the National Academy of Sciences brought to the criminal side of our legal system was the junk science debate. For the first time, we are going to have this debate moved in, not by defense attorneys, not by prosecutors, but by mainstream, objective, prominent scientists that are going to be reporting on their findings related to scientific evidence. And it challenged the received wisdom and a century of legal precedent, creating a real litigation boondoggle going forward. And this is particularly true because although Daubert has been widely adopted, many states, including some of the most populous states or the most populous states in the country, have retained Frye. Many have small variations of, the essence of Frye that I spoke about earlier, but essentially have Frye. So it's California and Illinois, and Minnesota, and New York, Pennsylvania, and Washington. So this talk is not a historical talk, it's relevant here today. And some of the factors that have been reshaping the Frye Standard is what I'm going to go into next. And they relate specifically to the use of unreliable forensics, largely in our American criminal justice system. This is, and I wanted to give like kind of a basic of what the, a century of interpretation of Frye has really kind of boiled down to these component parts. Is that it became, because if you think about, we talked about general acceptance, and that if something had gained general acceptance, it's going to be admitted. And that what it suggests, of course, is that the science has to be fairly established to be admissible. But you would only get a challenge, you'd only be able to challenge it if it was a novel technique. In other words, the person or the party that was challenging the introduction of the evidence would have to show that this is new. This hasn't been generally accepted, and I'm challenging it for those reasons. Now, I added discredited because in the post-DNA, forensic DNA world, and the post-NAS world, some of these techniques have been discredited. And what do we do with the novelty requirement? If something is already in the law said that it's valid and reliable, but has been overruled by scientific reality, what do we do with that? So I'm going to talk a little bit about that in a minute. That it must be based on scientific principles, right? And we can have a lot of debate on what that means, but it essentially means that the technique has been subject to the scientific method, to those factors that we pointed to in the Daubert 5 factors, right? That's something that you can make that determination by looking at the technique and see, has it been subject to peer review? Has there been scientific research? Is it testable? These are the things that are scientific principles. And like Daubert, that relies, that reliability being the touchstone, is it's whether or not it's been generally accepted to produce reliable results, right? So reliability is an important part of the Frye test in most jurisdictions as well. The general acceptance that we have talked about, this is a nose counting exercise, but the last one, number 5, has been a very, very important and contentious area of litigation, because in many techniques, how you define the relevant scientific community is outcome determinative, right? So we have to decide, and courts will have to decide, how they're going to define that in any particular Frye challenge. Now, the other side is that Frye is also used, and so is Daubert in this way, is that you can say that a forensic technique or some sort of scientific matter has been generally accepted, but it hasn't been properly applied, or it's been in a novel way been applied in this particular case. In other words, you're not saying that this entire field should be excluded, but it was done in a novel and unacceptable way in this particular case. So it's kind of an as-applied challenge, and that you also have to have expert witness competency. You might say that challenging the methodology that this particular expert, has been using. So that's, essentially a contemporary interpretation of the Frye test boils down to these factors. So what we've been doing as criminal litigators for, since the NAS report and beyond, is that we have been arguing back and forth, about what is novelty under, what does it mean to be novel? Because, in 1923, you weren't having the kind of explosion of technology that you have today, and you weren't getting kind of new iterations of old forensic techniques every 10 minutes the way that we do now. And it used to be, and it was pretty clear, that you really wouldn't be able to get anything that you couldn't really establish was novel. And so I picked a relatively recent New York Court of Appeals case to kind of unpack some of these new issues around the interpretation of Frye. People v. Williams and Foster Bay, these are two separate companion cases that were in the New York Court of Appeals is the state high court. That's, many courts, that state high court is called the Supreme Court. In New York, it's called the Court of Appeals. So I quoted some language here that kind of demonstrates the influence and some of the problems with kind of the old-fashioned interpretations of Frye, and that the court said that we had said that Frye hearing is generally unwarranted absent a novel or experimental scientific theory. And then this is what comes into what we're talking about with in 2023 is that, however, familiarity does not always breed accuracy, and our Frye jurisprudence accounts for the fact that evolving views and opinions in a scientific community may occasionally require the scrutiny of a Frye hearing with respect to a familiar technique. And that sounds mild, but it's actually somewhat groundbreaking, and it's kind of harkening back to some earlier concurrences by Chief Justice Judith Kaye made in much earlier prescient concurrences in a case called People v. Wesley. And then it went on to kind of note why it is that this has become an important principle, is that you can't just have only novelty being the rule as to whether or not you get a hearing, because the jurisprudence that would say today that all these techniques that we've been talking about are valid and reliable, but it's saying here, indeed, admissibility, even after a finding of general acceptance through a Frye hearing, is not always automatic. Recent questions or recent questioning of previously accepted techniques related to hair comparisons, fire origin, comparative bullet lead analysis, bite mark matching, and bloodstain pattern analysis further illustrate that point. All of these analyses have long been accepted within their relevant scientific communities, but recently have come into varying degrees of question. So what this demonstrates is that, one, is that we can't just rely, and courts are no longer, certainly many more, are no longer having as a threshold issue novelty, because science changes. There's no such thing as stable, static, concrete science, right? There's no certainty in science, right? And we have to accept uncertainty if we're going to use scientific evidence. What we know today may not be true tomorrow, right? Bloodletting was used in the medical industry for 2,000 years, right? And then if the case law said that it was still good for curing a headache, we wouldn't be using bloodletting to cure headaches, right? So the same principle applies to forensic techniques or any other scientific evidence. But the relevant scientific community, this has been a very contentious issue. I'm sure that you'll see other speakers during this series that will disagree with me about how this ought to be defined. But the reality is that if you define the relevant scientific community as those who have a professional interest in the continued acceptance of the field, those who make their livings in this field, those whose professional egos are wrapped up in the scientific validity of these fields, then you're really never going to have an objective opinion as to whether or not a field is reliable and whether or not it actually is generally accepted by people who have no interest in the outcome of a Frye decision. In other words, a physicist doesn't care if fingerprints are admissible or not, right? But a fingerprint analyst does, right? That's the whole point. And so defining the relevant scientific community had been for a long time, and all those discredited fields that the Court of Appeals of New York pointed out had for years defined the relevant scientific community as those forensic experts that are practicing in that field. And it makes a certain amount of superficial sense, right? Because they're the ones that really know how it works, right? But they're not many of them are not scientists, for one, have not had PhDs or training in hard sciences, but more importantly, is that they have been taught this methodology by mentors that are passing down received wisdom from field to field, from generation to generation. And as a result, to work in the industry, you have to accept the premise that it's valid and reliable. Otherwise, you wouldn't work in the industry. So this has become more and more clear in the jurisprudence, and certainly in the civil side of litigation, and that includes these states that still use this Frye jurisprudence for their civil matters too. They have become increasingly aware of this issue and expanded the definitions of the relevant scientific community, which of course include practitioners of a field, but there have to be other members of the scientific community can weigh in on the validity and reliability and the general acceptance of a particular technique. So the Williams Foster Bay cases made this point, and this is it says in short, the FST. This is a forensic statistical tool that was related to the interpretation of DNA mixtures that was at issue in this case, and it said should be supported by those with no professional interest in its acceptance. Frye demands an objective, unbiased review. So this is the Court of Appeals acknowledging that if we define it as those who develop the FST program, then there's really no issue for the court to decide. Again, this was a bite mark case that we were involved with in Pennsylvania, and said that we are likewise persuaded by appellant's argument that the trial court should not have limited consideration of the general acceptance of the expert's methodology, in this case, to the field of forensic odontology. So forensic odontology is just forensic dentistry, a fancy way of saying that. And what this was an appeal from was the denial of a Frye hearing in a capital case that we were helping to litigate. And what the court said was that, A, this is not novel at all. Bite marks have been around for 50 years, and defined it as, and it's generally accepted within the field of forensic odontology, right? The bite mark experts, the people who invented the whole technique to begin with, right? So we lost. And so we did an interlocutory appeal, and the court, and it's a very, really straightforward opinion saying that you can't just limit it to these people. Otherwise, how are we going to explain the relevant to the broader community, where it may continue to admit a field that's responsible for at least 40 wrongful convictions and indictments, right? That doesn't make any sense. So that's what the Ross decision essentially holds. There's another earlier decision in Michigan that makes essentially the same point. You don't want people whose livelihood is not intimately connected with the technique at issue to be deciding its admittance. And I have an important point down there at the bottom. And what that point is that if you go back to the original Frye case itself, right, they didn't rely on the proponents of lie detectors or those who are, engaged in detecting lies to decide whether or not it was admissible. What they said is that we don't think that the scientists that are involved in physiology and psychology have accepted this, right? They're the ones whose fields would necessarily be implicated in the use of a lie detector test. And so we are not admitting it. So this principle has kind of come full circle back to the original Frye test and saying that we have to have broader definitions of the relevant scientific community. We can't rely only on novelty. And it has to be based on scientific principles. And really what we courts understand now, even those courts that don't use the Daubert standard, the Daubert factors have given lawyers and jurists a roadmap for the consideration of scientific testimony. In other words, what does it mean to be scientific? Something that lawyers typically don't learn in law school, and we're still learning more and more about every day. Thank you so much for your time.
Hello, everyone. I am John Grassel, the co-principal investigator with the Forensic Technology Center of Excellence. Thank you, Chris, for providing such an informative presentation. We will now ask the audience a few poll questions. Please respond to the poll questions as they appear. And as a reminder, your responses are anonymous. This is a judgment-free zone. We will leave the polls open for about 30 seconds to give everyone a chance to respond, and then we will share the results. For our first question, prior to this presentation, did you know the significance of the Frye test had originally expanded due to the increase of personal injury litigation? Yes or no? And thank you for your responses. Let's look at the results. So 85% chose no and 15% chose yes. So that's good. So that way we know that Chris's message came through, at least for that, right? And our second question is, which court case expanded the definition of the relevant scientific community to include those with no professional interest in its acceptance for Frye jurisprudence? Please select one answer: People v. Williams, Commonwealth v. Ross, People versus Coy. Okay, thank you for your responses. The correct answer was A. So pat on the back for all those who chose A. Thank you, Chris, for providing such an informative presentation.